This is TWiT. Let's talk about the Florida social media law, because, Cathy, you've got an article in this week's Tech Dirt about, and the way that Tech Dirt capitalizes titles, this is good. The problem with the otherwise very good and very important 11th Circuit decision on the Florida social media law. So first of all, is SB 7072 like the Texas social media law?
Okay, so we can't escape this conversation not talking about Texas. Texas is also going to be relevant to what we're talking about. And Texas just filed something at the Fifth Circuit saying our bill is totally different than the Florida one. So this 11th Circuit decision that largely threw out the Florida social media bill, the counsel for the plaintiff appellant, the plaintiffs who are challenging it, submitted as supplemental authority, like, Dear Fifth Circuit, while you consider authoring an actual decision about how you want to adjudicate this appeal, you might want to know that your fellow circuit over here took the bulk of a law that was trying to regulate content moderation in general, and said the 11th Circuit found that it implicated the First Amendment rights of platforms. So they just went back to the Fifth Circuit and said, by the way, you might want to know that that's how a fellow court decided things.
How bound is the Fifth?
To that,
these are both federal courts of appeal, but is the Fifth in any way bound by what the 11th does? Are they a completely standalone independent?
So they are standalone independent. The 11th Circuit would be regarded as persuasive authority, but the circuits are free to do what they want, except they're all supposed to follow circuit precedent and national precedent. So if the Supreme Court has actually articulated something, then the circuits are all bound to, they're not supposed to come up with
Yeah.
They have to be consistent with what the Supreme Court said. Now, that gives you a lot of wiggle room as a court, because then you basically try to argue that what the Supreme Court said is inapplicable to the case before you. Right. But they're supposed to follow that. So when the 11th Circuit looks at Supreme Court precedent and says, based on the things that the Supreme Court has said before, when we apply it to this type of law, we think that there's a problem. It's bumping up against the First Amendment interests of the platforms, and we've decided that's unconstitutional. But the problem is, and the reason we have to go back to Texas is, so both states had their own laws that they came out. Florida had their law, which involved the weird theme park exception, where it applied to all platforms unless they happen to also own a theme park as part of their corporate assets. And Texas,
which, by the way, given how Governor DeSantis feels about Disney these days, they probably wouldn't have left that in.
Oh, they took it out. They actually literally took it out. They amended the law while it was getting in the appeal process. They actually
Disney, we don't like you anymore. You're too woke. We're taking you out. So
they took it out, and then they wrote to the court while it was busy, chewing on this decision, to update the court to say, by the way, the theme park exemption is no longer in the
that's
in the
hysterical.
Law. But it's kind of like, from the other side, the people challenging it, it's kind of like, yes, they're right. This just shows how arbitrary and capricious and how offensive it is to First Amendment editorial judgment that, like, you would toggle it about, like, who your political enemies are, and this is who you're going to target with your law.
What was the show title last week, Leo?
I don't remember. What was it?
About laws that are made just for one party?
Is this a quiz? I was only half here last week. I don't remember.
Oh, no, it wasn't last week. Oh, hell. It was October. No, it was the week before that. Never mind.
The gotcha moment failed.
It did. I just got myself, yeah.
Well, so
Bill of
both
Attainder. It was
Bill of Attainder.
Oh, yes.
Good old Bill of Attainder. Who could forget him?
William of.
Yes.
So both states had these laws that kind of did slightly different things. Like, they had a slightly different focus. Florida's is more about journalism and political campaigns, and Texas, maybe that was the political campaign. They had a little bit difference in their orientation, but basically they were fundamentally that the state wanted to tell big tech platforms how they got to do their moderation and put a lot of onerous requirements that would take away their ability to do it freely.
Let's be in the new spirit of calling things what they really are. This was don't ban Donald Trump from Twitter law.
Yeah, it boils down to how dare you
and others. But
yes.
You're not allowed to ban Donald Trump from Twitter law. Okay.
Right. So
Cathy,
both
I've got a question for you. Oh, you keep going with that. I'm going to have a question for you. Keep going.
Okay. So both states had laws like these, and both states' laws got challenged. And in both instances, district courts looked at them and said, we're going to enjoin this, or at least most of it, because we see that this is conflicting with the First Amendment rights of platforms. So the laws were enjoined. Nothing could happen with those laws. Then each state appeals because they're unhappy with that. They want their law. So Florida appeals to the 11th Circuit, and that appeal was heard first. But then we were waiting for a decision for a while, which is not abnormal. It usually takes a long time to get a decision. And then Texas had appealed, and that was heard by the Fifth Circuit in an oral argument that didn't really go very well. It was very strange,
Yes.
sort of some of the questions being put back at the plaintiffs. But then it quieted down, but then all of a sudden, out of the blue, 2 or 3 weeks ago, both laws were currently enjoined, and then the Fifth Circuit, with no explanation whatsoever, came out of the woodwork and said, with a 2-to-1 decision, we're going to stay the injunction, which basically in this one-line order said, guess what? The Texas law gets to go into effect right now. Whatever constitutional effect it has, be damned. It wasn't going to talk about it. It didn't explain why it thought it wasn't defending the First Amendment. It put it in, and the Texas law is active law right now.
Pending, of course, it's still on trial and pending a judgment down the road, but it's
pending that
now.
They actually issue a ruling on its constitutionality, which we're still waiting for.
Right.
So then this led to an emergency application to the U.S. Supreme Court by the plaintiff challengers to say, hang on a second, we need some relief because this is a really bad law. We definitely think it's implicating our First Amendment rights. And how can this be live? We can't even appeal it because there's nothing to appeal because there's no decision. So we shadow docketed. There's an emergency application to the U.S. Supreme Court to ask it to give some relief, and I wrote an amicus brief in support of this, so I have shadow docketed too.
Oh, good
And so
for
now
you.
we're waiting.
But
yes, this is quite of a big deal. But
the justice in charge of the Fifth Circuit is Samuel Alito.
Justice Alito. Now, he did issue an order to make the state respond. So the state had to put in a filing. So there's some tea leaf reading that suggests that this is being taken seriously, but we've now been waiting.
He could do two things. He could send it back, say, nope, not going to get involved. Or he could then refer it to the other justices.
I'm not entirely sure what all the options are because this
Shadow
is also
docket is so
really
weird.
It's underarticulated. The U.S. Supreme Court is normally very regimented with a ton of rules, including if you're filing like as an amicus, there's a ton of rules ordinarily. But in this case, there's no rules. They have some proposed ones, but basically this is sort of like they're making it up as they go along, which is really not something you want to see in your judicial system. But nonetheless, it's sort of as a litigator, it gave you a little freedom of like, I didn't have to spend money on expensive printing because that wasn't a rule here. We just kind of shoved it in with this looks reasonable. I think they'll take it. But this is really not how you want to do your litigation.
We're seeing more and more of these shadow docket orders, unfortunately.
Right. So where we are now is nothing's come out of the Supreme Court yet. Nothing's come out of the Fifth Circuit to explain its order, but early this week, the 11th Circuit, I think, rushed out their decision, and their decision took aim at most of the Florida law to say this is really colliding with First Amendment rights of platforms, and gave a very full-throated analysis to talk about how a lot of the arguments like common carriage and this, that, and the other thing were like, nope, this is wrong. You've really done something that's unconstitutional. So it mostly continue the injunction on most of the Florida law. My textured post is raising concern that they didn't fully enjoin it. They let a few provisions go through, and I think it's problematic that they did, but it's not the end of the litigation train for that. But that only shuts down the Florida law. The Texas law is still live, and we need somebody to give us some relief or at least some explanation on why did the Texas law get to go into effect, given that the 11th Circuit has just articulated a very sensible basis of why these types of laws are hugely problematic and interfere with First Amendment rights of platforms.
Did Florida or will Florida then send that to the Supreme Court, or do you know? Or?
I would not I would not be surprised if they did, but to do
Who is the justice in charge of the 11th Circuit?
All the judges on the 11th Circuit who rendered this unanimous opinion were all appointed by Republican presidents at some point in time. One is a Trump judge, one is, I think, is a Bush judge of some sort, and I think one was a Ford or somebody. So, Yeah, so this was something where even conservative judges
Clarence
looked
Thomas,
at it and said there's a problem.
Clarence Thomas is the justice who would hear a shadow docket appeal.
Oh, jeez. Oh, no.
So anyway.
Oh, I see what your point is.
Yes, you get what I'm saying? Who's the Alito for the 11th Circuit? It's Clarence Thomas.
Oh,
Well, so the other thing, though, is, so I told you there were amicus briefs that went in support of this emergency application. Most of them went in support of the amicus application, but there's two went in support of Texas, because Texas had to say, no, our law is totally fine. Leave us alone. Nothing to see here. Go away. And they had two amicus briefs, one of which was by Florida, and I think a bunch of other very red states that showed up to say, this is totally fine. We should totally be able to regulate the internet the way these laws are articulated. So they've kind of already presented themselves to the Supreme Court a little bit, and I don't think it's a mystery to the court what Florida thinks about it. But the procedural posture of this is very strange. It's always strange a little bit because there's always options and sort of like chess strategy that you get to play out in terms of how do you litigate something from beginning to end. But it's definitely extremely strange because we're in shadow docket land and normal rules are not applying. And what the Fifth Circuit did to, in that one-line order, unleash a law that there had already been a very articulate decision saying was unconstitutional, and they just let it go out into the world anyway.
Let me ask you,
that's very strange from an injunctive standpoint.
Let me ask you, if these laws were about a newspaper instead of social media, would there still be the same back and forth over this, or would it just be, no, obviously, you can't do that?
There are some open questions about what is the right analog to apply to the internet. So to some extent, this is not completely ridiculous. But on the other hand, there's some really weird analysis of precedent going on with this. So I wouldn't even trust that newspapers are necessarily safe. We're kind of making it up as we go along.
That's where we are now.
Oh, okay.
Yeah. Can I ask another question, Cathy, that puts it into... I make the First Amendment argument, obviously, constantly, and that compelled speech is not free speech is a tattoo I'm going to get put on my chest. But I have a different basis for this question. If a bar can say, I don't want to serve Leo. I don't serve people in white shirts. I don't like them. You can't come in here, right? They have that right.
I should explain. I am wearing a white shirt today.
Oh, sorry. Yeah, for those who can't see.
Narrator.
Very old.
White shirt.
It's not some sort of euphemism for anything. I just happen to be wearing a white shirt.
The secret McKinsey consultant. So it's a white polo shirt.
Yes.
Give me. Right. So, but a bar as an establishment, as a private establishment, could say we choose whom to serve, as long as you don't do it on the basis of race and other protected classes, right? Why is that not also the same for a Twitter, that we choose not to serve?
That's what I was kind of getting at with my question too. Are we tweeting social media as different somehow from what standards would be for other businesses or journalism, but apparently not.
Well, I lost the thrust of that question. But
he's saying basically a business can say no to Leo. I would say you can't tell a newspaper what it can or cannot do, and that seems like established law. Why is it that we can?
How can you suddenly tell Twitter whom they must serve?
So the argument that Texas and Florida would make is that they start to throw out two ideas. Both of which were fully rebuffed by the 11th Circuit, and correctly so. But one of them is this idea that social media is, quote unquote, and I use it in quotes derisively because I don't buy this at all, but it's the new public square. Yeah. And that if you are the new public square, you have a different sort of duty to all comers. And this is the second idea that they throw around, which is, and you are a common carrier, so therefore you must take all comers. So they basically try to look at these businesses and say, oh, no, you're not the bar anymore. You're something special because you're different and you're so integral to the functioning of modern society that you are now subject to additional regulatory burdens that strip you of editorial discretion, and now you have to serve all comers.
Which leads you even farther down the path that you would have to accept everything legal.
Yes.
Would have to be accepted.
Yeah. I mean, one of the things that's been argued in these appeals is, And it came up like while this was getting litigated. The emergency application to the Supreme Court was pending when we had Buffalo. And there was the issue of the culprit had live streamed it and Twitch took it down. And there's a very arguable case that under the Texas social media law, it was not legal for Twitch to take it down. That's a really terrible situation we're in if platforms really have their hands tied where some really awful content cannot be removed because there's liability associated with removing content. Like, this is not the world we want to live in.
But again, it's very clear that neither legislature was thinking about things like that. They were thinking about Donald Trump. And these are very purpose-built, jerry-rigged, with the most ridiculous arguments, laws, that baffles me that they are getting any protection at all from the courts.
Well, I mean, the only protection
if Apple says Leo can't come to an Apple event, there's no one to say that's. I mean, no one would reasonably say that's illegal.
Not you, Leo. It's your wardrobe.
Well, whatever. I mean, and it seems to me that's well-established precedent.
Yes.
And the fact that they're coming up with these Fakatka ideas that it's a public square or it's a common carrier, it's BS. And I'm amazed that the Fifth Circuit could even, countenance that.
Well, yeah, I mean, and it's not entirely clear to what extent the Fifth Circuit, how badly it got it wrong, because it hasn't shown its work, so we don't know quite how badly it got it wrong.
Why is that? Why is that? Is that a new thing too? I mean, I guess if you have a full ruling, you write an opinion. That's the problem with the shadow docket too, isn't it? That there's no opinion.
Yeah, there's a very judicial process as we've known it it evolves over time, but it's definitely been taking some very sharp left turns. I don't mean left, right in a political sense, but just sort of like all of a sudden shifting from staid, boring, evolving slowly into all of a sudden some pretty radical changes of how things happen.
These are all originalists and constructionists doing it. That's what's hysterical.
Yeah, I mean, and originalism
so-called
is like
originalists. Yeah.
I mean, and the originalism runs into a problem because they're all like, well, this is what was true in 1780. It's like, yeah, but we also had the 14th Amendment. Like, we had the Reconstruction Amendments because we had to tune things up.
They're not originalists. It's obvious. They're not constructionists. It's obvious. They just use that as cover.
No.
The judicial process itself can change without really offending the Constitution. The problem is it depends what it's changing into. And right now it's changing rather radically where they're changing the rules on the fly in a way that sort of poses the end they want to actually achieve. Like, process tends to beget substance. And so very sort of, this is just a change in how we judicially process this case, all of a sudden is having huge substantive effects. And the Fifth Circuit in particular has been very troubling in sort of how it's been handling itself. And it's then feeding into the Supreme Court, which then also has been changing the rules about how it processes cases. And all of this has been having tremendous substantive effect. And all the lawyers who like litigating these courts are kind of like throwing up their hands of like, I don't know what the rules are anymore. This is, and I will get back to it because I think it's a fair accusation, it's turning the courts into Calvin ball, and this is not a great way to have rule of law. The fact that I can train as a litigator and I'm still in the dark about what it would actually take to press a client's case, that's not an okay position to be in. Like, all the skills I have are kind of like, yeah, maybe they're useful, but it's a whole new ballgame now, and it's not supposed to be a whole new ballgame right now.